Contracts. This, of course, is one of the most important topics for a business law class, and certainly for business majors. All of us enter into contracts. When you sign a contract for cell phone service, for utilities, for your apartment, your house. If you have purchased a car, you signed a loan contract for the loan. For a mortgage, if you buy a house. A lease, when you rent. In fact, it's actually kind of amazing how many contracts we as individuals sign. And the older you get, the more that's going to be true. And obviously in business, it's extremely important. If you're a business owner, you have contracts with vendors and other suppliers, with customers, with people who provide services to you, landscaping services for your building, cleaning services for your building, many, many other things. Professionals like lawyers and doctors and accountants contract with clients. So contracts are pervasive and extremely important. And as a lawyer, especially, I would often be asked, well, do I need a contract for this? Small businesses. Do I need a formal contract for this? And I was always amazed how many small businesses worked on a handshake, essentially. Minimal information and very simple contracts. Many small businesses are afraid to have lawyers. They don't want to spend any money and then, often pay for it later because they could have covered something by contract. So as we go through this, you obviously need to learn the essentials of what makes a contract enforceable in court. But part of this is intended to get you thinking about why are contracts important? Are they overused, underused? When should they be used? And just some very practical things. So we'll begin with the definition. What is a contract? Well, this is one thing where the definition is quite simple. The definition of a contract is mutual promises between two or more entities or people to do something in the future. Now, sometimes the do something is almost instantaneous, but most of the time it's a promise to do something in the future. When two businesses contract, one promises to deliver product, like a manufacturer, to a retail store on a certain date, and the retail store promises to pay in the future. So it's pretty simple. Mutual promises to do something in the future. Now, like with everything, there will be some exceptions to that general rule. And a breach of contract is broken promise. Sometimes multiple broken promises. Now, in life, we make promises all the time to people. You tell your friends you're going to do something and you don't do it. You tell people you're going to show up and meet them someplace. Or you're going to come over and help a friend, work on his house or something like that. And sometimes you follow through and sometimes you don't. So there are lots of promises we make and break, and there's no law involved. There's no legal right to sue. What we're talking about for contract law are promises that are enforceable in court, if necessary. Now, not many cases or broken promises go to court, but the idea is that you could go to court and sue for breach of contract, which would be the cause of action, and try to get the other side to do what they promised to do. So it's pretty simple, broken promise. At least it sounds simple. Obviously, there's a lot more to it than that. I like to talk about the public policy of contracts and contract law. With the exception of constitutional rights, I don't think there's any other area of law that people in business, judges, lawyers, take so seriously as contract law. And let me digress for a moment here and kind of give you a big picture perspective on this. I think I've mentioned I've had the privilege of teaching in Europe, in both France and Germany a number of times. And I've had international students both at Wichita State and obviously in Europe. Many of my European students came from China, India, and all over Europe, Africa, South America. So in talking to many students over the years, from places like Russia, Moldova, the Philippines. I had quite a few Philippine students. One of the things I got from that really was quite gratifying to me was the perspective, particularly of those students who hadn't lived in the United States, the admiration of the United States legal system. In that when you live in a country like the Philippines and some of these other countries I've mentioned, there is a fair amount of corruption in government and even in the court system. And I've heard that from actually Filipino lawyers. And it may have gotten better in recent years, I don't know. But the point is, when you're a business person, you need to make contracts, and you are very dependent on other people and other companies making promises to do something in the future. And if they don't follow through, you lose a lot of money. The best way it's like a deterrence. The best way to get people to do what they're supposed to is to have a legal system that enforces those contracts. A legal system that is consistent and fair. Not perfect, there is no such thing. And it is true, the American legal system has to be one of the most fair, objective in the world. And particularly with respect to contracts. I can tell you, having practiced law for 20 years and had a number of breach of contract lawsuits, including some trials, judges take contracts very, very seriously. And that's what I mean by the public policy of contracts. Why? Well, first, commerce. Can you imagine how it would be in the American business system if people made contracts that they couldn't get a judge to enforce? You would have the unethical people in society, and there are plenty of them, who continue to take advantage of people. It's already a problem. Nothing's perfect. In fact, this is a really important point. No contract is ironclad. I used to have clients sometimes say to me, Spurgeon, write me a contract that I can use when I'm doing business that is bulletproof, meaning, I can't get sued. Well, there is no such thing, and I'd always tell them that. What we're talking about is relative terms. But clearly, we need a legal system that enforces contracts in order for business to survive, to be successful. And by risk management, the way I look at contracts for particularly small businesses, but all businesses, is most people you do business with are honest and take pride in the fact that they do what they say they're going to do, worry about their reputation. And you probably wouldn't need a contract with those folks. A handshake might well be good enough. And at the other end of the spectrum, no contract, as I said, is bulletproof. If somebody wants to rip you off, they will. They can file bankruptcy, they can shut their business down and leave the state, or they'll just make you sue them. And if they don't have any money, you can't get any money out of them anyway. Great, got a lawsuit. Now try to collect it. So understand that there is no absolutes here. But I see contracts as a risk management tool. Meaning, if you have a contract with your customers and with other businesses, you may or may not ever need to go to court to enforce it. But by simply having it, it's going to make the other side take you a little more seriously. It's out there hanging over their heads. Not that you're threatening, but the fact that they signed it, they put it in writing, they have bound themselves, really does, I think, increase the possibility that the person will be good for what they promise. So, public policy of promoting commerce and as a risk management tool is very important. Now, what I want to do now is go through three scenarios. I've used these three scenarios for quite some time, actually, and intended to get you to look at a transaction and ask yourself the question, is this not just a contract, but a legally enforceable contract? Now, I'm going to go through it. I'm going to give you the facts and ask you rhetorically what you think, and then we'll come back to it in a little bit after I talk about some other stuff, and then revisit that. Scenario one. You are at a friend's house watching the Super Bowl, and your friend has this really nice TV, at least compared to your old dinky little TV. and you're admiring it, and you're telling your friend how much you like this widescreen TV, and your friend says, yeah, it's pretty good, but I want a bigger one, and I'm going to go buy a bigger one here in the next few weeks. And I'll tell you what, you want my old TV? Because I'm just going to have to junk it. And you're like, you kidding? You're just going to give it to me? And your friend says, sure, yeah. When I get my new TV, I'll give you this old TV. And you think, great. Several weeks go by. You run into your friend. Hey, did you buy that new TV yet? Yeah, I did. It's great. Way bigger, much better. And you're thinking, well, what happened? But you said I could have your old TV. I hadn't heard from you. Oh, that. Oh, I forgot. Yeah. Yeah. When I got the new TV, I decided to give my old TV to my cousin. Sorry about that. No. Is that contract? Was your friend's promise to you to give you his old TV a contract? And I'll just cut to the chase quickly on this, because you can probably tell it's not a contract. Now, I'll give you the legal technical jargon for it later, but let's just use common sense. Your friend made a promise to give you something. That's the key word, a gift. You did not make any promise to your friend. You're not giving your friend anything of value. All enforceable contracts have, and the legal term we'll talk about later is consideration. Both sides get something of value. Both sides give up something of value. You weren't going to give your friend anything, and therefore this is not a contract. So general rule, remember, the general rule is that a promise to make a gift in the future is not legally enforceable as a contract. Now that's what you need to know. There is something that confuses people, and that is under property law, which we'll talk about later. If you actually give somebody something and deliver the gift, under property law, you can't get it back. But it's not a contract. We're talking about here a promise to make a gift in the future, and it is not enforceable. So this isn't even an enforceable contract at all. Second scenario. You have a friend who lives in that cute little house, and your friend obviously is quite an avid gardener. And one day you get a text from your friend saying, hey, I have been called out of the country. I'm going to such and such country overseas. Cell phone service and email is terrible. I will be out of pocket, as they say, for a couple of weeks. Would you please go water my plants while I'm gone? If you do that, I will pay you $50 when I get back. Thanks. When you receive the text, or it could be an email, it's too late to contact your friend. She's gone. And you don't have a chance to call up and say, hey, let's negotiate this. I want $100 or anything like that. You have two choices. You can either water the flowers while your friend is gone and trust that your friend will pay you the $50 in the future, or you can just say, out of heck with her, I'm just not going to water flowers. The flowers die, your friend is upset. And that's what you're facing. So you decide to go ahead, well, I'll do it. I water the flowers and do everything I'm supposed to. Flowers in great shape. Friend comes back and you say, here, I watered your flowers. Where's my $50? Your friend says, oh, yeah, that. I was thinking about that on the flight back. I've done lots of stuff for you over the years. I think as a friend, you should have just done this as a favor, so thanks. Your friend doesn't pay you. Now, is that a contract? Is it an enforceable contract? Let's take it a step further. Can you sue your friend for breach of contract in court and get a $50 judgment? Now, practical point, it would be stupid to go to court for $50, even small claims. But the point is whether this is an enforceable contract. I'll talk about the details later. The answer is yes. This is an enforceable unilateral contract. In a unilateral contract, one party makes a promise. Your friend promised to pay you $50 in the future, but the other party never gets a chance to make a promise because of circumstances. Unilateral means one promise. it is a contract that's enforceable because you accepted the contract by performance. You see, in most contracts, the acceptance is, yes, I will do that, and I will water your flowers, in the future. Here, you didn't have a chance to do that, so by performing, you have accepted the contract. And because of that, both sides got something of value, clearly. Therefore, it is an enforceable contract. You could sue your friend and win. The third scenario is a little trickier for a couple of reasons, and like when I would do this in class, I'd spend a fair amount of time on it. You have a bicycle, and you like it, it's fine, but you want a newer, bigger, fancier bicycle, and so you decide to sell yours in one of these online services where you can post an ad to sell something. And you post this little notice, and all it says is bike for sale. You describe the brand, the brand and the type of bike, and then you just put $550. That's it. Name of bike, type of bike, for sale, $550. You then get a response from somebody and the response is, I'm interested, but I will only pay $400. That's all. That's all the response you get. Okay, no, stop right there. What you've done is to make an offer or not. Have you made an offer? I'll come back to this point later. Technically, you didn't make an offer. You just posted an invitation for people out there to make an offer. So something to remember when I get to this concept later, the first offer here is actually the person who offered $400. You then reply to the person, 500. That's all you say, just 500. And back and forth and back and forth. And at some point, you both come to a meeting of the minds for, let's say $475. And then you make arrangements to exchange bike and cash. So sort of like, I will take bike to such and such location, and you will give me $475 cash. That date rolls around, you throw the bike in your car, you drive over there, and the person doesn't show. You then contact the person and say, what happened? And they say, oh, I changed my mind. I actually found the same bike online for about $100 cheaper. Now, this is kind of serious, right? This is real money here. You had your hopes set to get $475 in cash, and now you still have the bike. Is this an enforceable contract? Well, let's break it down a little bit. Common sense. Were there mutual promises to do something in the future? Check. Were both sides going to get something of value if this transaction went through? Check. Were both sides giving up something of value? Check. So it looks like we have a contract, right? This is an express bilateral contract. The parties expressed the words to each other of what they intended to do. They made promises, and both parties made promises, thus bilateral. So it is an enforceable contract. You could actually sue, but here's a catch. And this is a very important point for contract law and all causes of action. Definitionally, it is a contract, there is a breach, and you could sue. But in all contracts, there must be damages. In other words, if you sue for breach of contract, but there are no actual monetary damages, then the judge is going to say, well, fine, but you still lose your lawsuit. Damages are an element of the cause of action. So the question then becomes, what are the damages here? Now you might think, well, the damages are you intended to get $475 and now you didn't get it. True, but you still have your bike. You're not really out anything, except maybe the gas to drive over to the location, but that's a minor point which is not recoverable. You still have the bike. If you were to bring a lawsuit in small claims for this and sue, the judge's first comment is going to be to you, this is premature. You still have the bike. I don't know what the damages are. How do I know that you aren't going to walk out of this courtroom and sell the bike for $800? You may come out very good on this. So go sell your bike, get the best you can for it, then come back later. In other words, you have to show that you really are out of pocket something. And what happens in the real world is you'd have to then sell the bike to someone else and see what you get. Now, if you get $475 or more in trying to sell it to somebody else, then you have no damage. You're not out anything. And the gasoline, by the way, and the minor inconvenience is not recoverable. It's really just the contract price versus what you actually got for it. Now, if you try for weeks to sell the bike and the best you can do is $400, what are your damages? $75. The difference between the contract price and what you actually got. Common law versus statutes. Now, we've talked quite a bit already about common law. Almost all contract law comes from the common law, case law, built up over really hundreds of years, both in the United States and in England. But we also have in Kansas and all states quite a few statutes that pertain to contract law. So how does it work? Well, this is the way I want you to think of it. It's actually obviously very complex. Keep in mind all this stuff. I took 2 classes in law school on contracts. Okay, that's 6 hours of college just on contract law. So this is very complex stuff, but here's the essence of it. Most of the stuff we're talking about in these 2 lectures, most of the contract law that I dealt with in my legal practice comes from case law. And it's state law. It's Kansas law. Very little contract law is national. It's state law. And of course, it varies somewhat from state to state. What has happened is Kansas legislature over the years has seen some instances where it needed to modify the common law. In other words, the conclusion was the common law was defective in some areas, or we need to tweak it for public policy reasons. So sometimes the legislature tweaks the common law, and when a statute is passed, remember our hierarchy, the statute overrides the common law. But for everything other than where there is a statute on point, the common law still controls. So remember the common law and the importance of it. I've already touched on a little bit of this, but contracts can be classified a number of different ways. I've already mentioned unilateral and bilateral. Let me define them again. All contracts are either bilateral or unilateral. The vast majority of contracts, I mean, it's got to be, and I don't know, but it's got to be 90% plus. And in business contracts, it's got to be close to 100% are bilateral. Both parties make a promise to do something in the future. A unilateral contract was the flowers example, scenario 2 that I gave you. One person makes a promise to do something in the future. The other can only accept that offer by performance. Once you've broken out the contracts by bilateral or unilateral, then there are other ways they can be classified. There are actually quite a few different labels, but the 3 I focus on for this course are express, implied in fact, and what I'm going to call quasi, but it is also known as implied in law. An express contract is one where the parties express in words what they propose. The offer is made in words, the acceptance, the promises. Understand that the words, some people confuse this. They think an express contract is only a written contract. Well, all written contracts are, of course, express contracts, but so are oral contracts if the parties actually speak to each other. So think about it. When the parties to a contract exchange words, their promises, email, text, letter, a piece of paper they both sign, verbally, on the phone, in person, all of those are express contracts. And an oral contract can, in many instances, be enforceable, which we're going to talk about. I get a kick out of this little drawing at the bottom here because the guy on the right quite clearly looks like Mark Twain. I don't know what Mark Twain is contracting for, but implied in fact contract. This is an important concept. In an express contract, both parties have an intention to make a contract, and they express that intention to each other in words. For an implied contract, both parties have an intention to make a contract as well, but they express that intent, so to speak, not in words, but through circumstances. I like to joke they express it through, charades, symbols, but in reality, it is through circumstances, what's sometimes called a course of dealing or circumstantial evidence. Now, so remember that both an express contract and an implied fact contract, the parties have an intent to make a contract. It's only a question of how they manifest that intent. So there are a number of different examples I can use for that. The one I like to use is a CPA. You hire a CPA to do your taxes. You have done this for years, the same CPA, somebody who works out of her home. And you have a system down. Every year at about the same time, you take a box of materials to the CPA's house, usually make an appointment, and you have a shoebox you use, and you always put the stuff in it, you give it to the CPA, you talk about a fee, when to pick up the tax returns and stuff, and that's it. For several years, the CPA has charged you $250. This year comes around tax time, you call your friend and she's not home, your CPA. And you're out running errands, you think, oh, what the heck? And you just go by her house and you drop off your shoebox that has your name on it on her porch. Might not be the smartest thing in the world, but you do it anyway. The CPA comes home, sees the shoebox, and she says to herself, I guess that so-and-so wants me to do her taxes again. And she does the taxes. What we have is a course of dealing over the last several years, a system. And a fee, and you know what the fee is, and she knows what the fee is, and she would always just send you a bill, and give you a bill with when you picked up your taxes. On this particular occasion, the CPA does the taxes, sends you a bill. That is an implied in fact contract. It's implied by the past dealing between you, and I think when you put the shoebox on her porch, given the circumstances, it's pretty clear that you're expressing an intent to have her do your taxes. We do this stuff actually more often than maybe people realize. So that's how it works. Let me give you a twist on that. Suppose when the CPA picks up the shoebox, she says to herself, I've always charged her $250. I guess I forgot to tell her that I had raised my fee to $300. Oh well. She does the taxes, sends you a bill for $300. You're angry. You expected $250. Is there an enforceable contract here? Yes. There is an implied in fact contract for $250 because when you drop the shoebox out, that's what you understood the fee to be. Therefore, it would only be reasonable that you should have to pay $250. Your friend messed up by not telling you the price increase. Now let's change the facts a little bit again. Suppose when the CPA picked up the box and realized that she hadn't told you about her fee increase, she calls you up and says, hey, got the shoebox, that's great. Just want to let you know I've raised my fee to $300. Is that okay? And you say, oh, sure. Yeah, that's fine. You haven't raised your fees in years. It's fine. What is that? That is an express contract for $300. You see, an express contract doesn't have to be real fancy. In that case, you have expressed the words to each other, a meeting of the minds, you're good to go. Quasi-contract. This is the implied in law contract. I've used this example for a while. One day, you pull out of your driveway, this is your house, and you really love your house. You worked hard to buy a house, and when you pulled out of your driveway to go to work, let's say it was white. It was a cute little white house. And you came home at the end of the day and you're really tired, but you did notice as you pulled in the driveway it was orange. Well, your first instinct is, God, I got the wrong house. What the heck am I doing here? And then you realize, no, that is my address, and those are my pumpkins and my flag. What is going on here? Well, then you go up to the door, and you see taped to the door an invoice. And it says, services rendered, painting house, orange, $2,000, XYZ Paint Company. And you say to yourself, I didn't contract with XYZ Painting Company. I don't know who these people are. And you call them, and they say, well, don't you live at 521 Elm Street? And you say, no, I live at 512 Elm Street. And their response is, oh, no. They went to the wrong house. This actually happens, and I've known a couple situations over the years where something similar to this happened. Here's the law. There was no meeting of the minds at all. You never intended to contract with them. They didn't even know you. There was no communication. There's no implied contract. There's nothing. And actually, in this situation, there is nothing. They just went to the wrong house and painted your house orange. You don't have to pay them. What's more, you could go to court, and if they refuse to do it otherwise, have the court order them to paint your house back white. But a quasi-contract would work like this. You're in your house, getting ready for work. The paint truck pulls in. You see these guys get out with ladders and paint, and you notice that they're starting to paint your house orange. You're puzzled by this, but then you say to yourself, I was going to call in sick from work today anyway, even though I'm not sick. I just want to mess around on Facebook all day, watch movies. I don't like orange all that much. It goes with the pumpkins, but this house really needs painting, and I think these guys got the wrong house. I will hide inside my house all day and let them finish the job. At the end of the day, they knock on the door, hand you the bill, and you refuse to pay it. And a quasi-contract comes up when there's been no meeting of the minds, no contracting at all, but one party, you, took advantage of the other party's error and gained a benefit from it. And it would not be fair for you to get a free paint job that you actually wanted, as it turned out, by taking advantage of their error. You could have stopped them. And I know that may sound very convoluted and crazy, but that's actually a scenario for a quasi-contract. The court would pretend that there is a contract and order you to pay. But again, the key to that is you took advantage of the mistake. I've had students in the past say, well, but if they don't see you during the day, doesn't that make a difference? Like, what? That may be a proof issue, but you knew, and under oath you're going to have to admit that, hopefully. Otherwise they'll nail you for perjury. Statute of frauds. I talked a little bit earlier about the issue of oral contracts and whether they can be enforceable. And the answer is many oral contracts are actually enforceable. These are the 4 types of contracts, oral contracts, that can be enforceable in Kansas. So first, all contracts for the sale of goods for more than $500. The Uniform Commercial Code, I'm not going to go into a lot of detail here, is an example of statutes that tweak the common law. A common law contract, remember this, common law contract, there is no dollar amount cap. Oral contracts are enforceable, period, under the common law. Again, there's always a proof issue, but if you can prove that the oral contract was made and broken, then yes, you can recover, and it doesn't matter what the dollar amount is. That is why a service contract, hiring somebody to cut your trees, hiring an accountant or a lawyer, they don't have to be in writing. They're common law contracts. The Uniform Commercial Code has to do with the sale of goods. A good is personal property. It's an item that you can see and touch and move. Cars, bicycles, toasters, anything like that. One of the reasons I use the bicycle example is it is a good. And under Article 2 of the Uniform Commercial Code, all contracts for the sale of goods for more than $500 must be in writing, or they are not enforceable. So one of the reasons I made the price of that contract under $500 is to avoid that issue. If you made an oral contract to sell your bike for $550, let's say over the phone, that's not enforceable in court. Number 2, any real estate contract for the sale of real estate must be in writing. Number 3, any contract which on its own terms, on the face of it, cannot possibly be performed within 1 year must be in writing. Now, what is that? Well, probably the best example here is a lease for an apartment. Under Kansas law, a 1-year lease for an apartment or house is enforceable. An oral lease for 1 year is enforceable. But if the landlord and tenant make an oral promise of a lease that is more than 1 year, let's say 13 months, it is not enforceable. It must be in writing. And that would apply to number 3. And then a personal guarantee. I don't talk a lot about personal guarantees in this class, but they're important. This is where one person promises to pay a debt of someone else. It's a little bit like co-signing, if you're familiar with that, but the best example is the owner of a small business borrows money from the Small Business Administration for the business to operate, $100,000. The Small Business Administration will require the owner of that business to sign a personal guarantee so that if the business fails, the corporation goes out of business, the owner is responsible for the $100,000. That's pretty serious. They're very common. They must be in writing. Now, just as with torts, a contract has certain elements that must be proved by the plaintiff in a breach of contract case. We're going to go through these. The first element is an agreement, that there's been a meeting of the minds, the mutual promises part. And we're going to go through each of these in detail. Number 2 is consideration, which I touched on. Number 3 is capacity. Do the parties have the capacity to make a contract legally? And then number 4 is, I'm going to touch on a little bit, it just means, poses the question of whether the substance of the contract, the subject matter, is legal or not. We'll start with offer. Every contract begins with an offer. Now, there can be an offer and a counteroffer and so forth, but you got to start with an offer. An offer is when one party proposes a specific terms to a contract to the other. Back on the bicycle example, when you post an ad saying, bicycle, whatever it was, $550, that's not an offer. That's an asking price. It's an invitation to get other people to make an offer. It's very important to understand that an asking price by a business or anyone is not an offer. And the reason is this. If you're posting online for a bicycle of $550 was an offer, then technically every single person who responds by saying, I accept, has made a contract with you, and you only have one bicycle. So asking prices on new cars, used cars, not an offer. And I use this example kind of to make a point, although it's kind of silly. You go into a Quick Trip. Every day you have this routine. You go in and you get a bottle of pop, as we say in Kansas, and you take it to the counter, and it's whatever the price is, $1.75 plus tax. You know what the tax is because you do this every day, and you put down exact change at the counter and you walk away. Now, that's an instantaneous contract, so it's kind of a poor example in some ways. But let's just say, hypothetically, the Quick Trip clerk says, not so fast there. That will be $18.22. And you're like, whoa. I've been doing this every day. It's $1.75 plus tax. The shelf has a little thing down below the Pepsi. It says $1.75. What are you talking about, $18? And the Quick Trip attendant says, haven't you taken business law? Don't you know that a list price, an asking price, is not an offer? You made an offer when you put the Pepsi on the counter of $1.75 plus tax. I'm counteroffering $18. The point is, that's actually technically true. Here's another way to look at it. When you put the Pepsi on the counter because the shelf said $1.75, You are making an implied offer of $1.75. And when the clerk rings it up at $1.75 plus tax, the clerk, as an agent of Quick Trip, has accepted your offer. So you get the point. I also have the auction. Sotheby's is a famous auction house. The actual offer in an auction is the person who raises her hand or whatever, not the auctioneer's prattle. So when an offer is made, the offeree has three options. Can accept it verbatim, no changes, reject it completely, in which case all previous offers are off the table, there's nothing, or counteroffers. A counteroffer is a rejection of the offer and the making of a new offer. The tables are turned. So my example of the bicycle, going back and forth, making offers. Each time the person responds with tweaking the offer, it's a rejection and a counteroffer. It's pretty straightforward, but that's how negotiation works. Now, sometimes people make offers and they put a deadline on it. In business, we do this a lot. We'll send an offer saying, this is our offer. Offer is good to a close of business on May 12th. And by the way, close of business is understood usually to be 5 o'clock. So if you want a different time, you need to specify. What happens when the offer is open-ended? In other words, it doesn't say. The general rule is that the offeror can revoke or withdraw. It means the same thing. Legally revoke the offer at any time until it's accepted. So long as there's been no acceptance of the offeror can revoke the offer. There's even a variation on this, and this starts to get pretty technical. When the offeror puts a deadline on the offer, let's say close of business May 12th, and it's May 1st. The other party thinks, I got 12 days, no problem. Let me think about this. Well, here's a scenario that I actually saw happen. What if the offeror, before May 12th, then contacts the offeree and says, I changed my mind. I'm withdrawing the offer. You may be thinking, well, you can't do that. You just promised me. Well, but the promise did not have consideration. The general rule under the common law is, even if the offeror has put a deadline on the offer, the offeror can withdraw or revoke that offer at any time before that deadline, so long as it has not been accepted. Now, what is acceptance? Well, that's where it gets a little tricky. So let me tell you about the mailbox rule, because I think this will help illustrate. I had a case where this actually happened. A man was fired. They handed him some paperwork saying, look, you've been here 20 years. If you sign this paperwork saying you'll never sue us for anything, we'll give you 3 months salary. Think about it. You got 3 weeks. He came to me. We talked about it. He was trying to decide whether he should sue or take it. And we still had plenty of time within the 3 weeks. And one day I got a call from him. He said, you'll never believe what happened. I just, this morning, I guess it was actually a couple days before, he called me a couple days later. He said, on Saturday, I got up, restless night. I decided I'm not going to sue these guys. I want this over. And I decided to just accept their offer. So I signed the paperwork, the offer sheet, and I went down to Dylan's and I dropped it off in a mailbox in front of Dylan's. Okay? He said, but then when I went home, later that afternoon, the mailman came and I got a letter from my former employer. And in the letter it says, we are revoking our offer. He said, so what happens now? And I'm like, oh my gosh. So here's the deal. The offeror can revoke the offer at any time, as I said, until it's accepted. Under the mailbox rule, when you have letters crossing in the mail like that, the rule is that the revocation letter is not effective until received by the offeree, whereas the acceptance of the offer is effective when it is turned loose of by the offeree. In other words, when Bob dropped his acceptance in the mailbox, and it was out of his control at that point. He has accepted the offer, even though his former employer won't receive it for a couple of days. The revocation letter that was sent to him that he received on Saturday had actually been sent a couple of days before, but because he didn't receive it until after he had mailed his acceptance, there was a binding contract, and that is the way it turned out. So please understand the mailbox rule. It's always on a quiz and or test. Now, I say there's an exception about this revocation for an option contract. That just means that if somebody puts money with the offer, like earnest money, that changes the revocation issue. So if you put an offer to buy a house and you put earnest money with it, then the seller of the house, I mean, there's certain things they can't do, but don't worry about that for quiz or test. I just let you know that's what earnest money is about. There is also a different rule for the sale of goods, what's called a firm offer rule. And I'm just going to mention this briefly. If the contract involves the sale of goods, like inventory, and a merchant, a business, states an offer and a deadline, for that purpose, if both parties are merchants, then the offeror cannot revoke the offer until the deadline. But again, that's only if they're merchants, businesses, and only for sale of goods. I've already briefly touched on consideration and defined it. Each party gets something of value. Each party gives up something of value. Most of the time, this is very straightforward. One party pays money, the other party delivers product. One party pays money, the other party provides services. Your plumber, there are all kinds of examples. But you have to be, for it to be enforceable, there must be mutual consideration. There's always an exception. One of the exceptions, and I want you to remember this, is promissory estoppel. When there's promissory estoppel, only one party gets something or receives something of value, and the other does not. But we still make it an enforceable contract as a matter of justice. Now, the Hamer versus Sidway case, which is kind of fun, is an example of an exception to that. It's a very famous case. It's actually the most famous case in contract law from law school. It's a very old case, obviously. Very simple. A rich uncle says to his nephew, who was turning 18, "I want you to be a good, upstanding young man. Therefore, if you will promise me that you will not smoke, drink, cuss, or play billiards for the next 3 years to your 21st birthday, I will give you $5,000 at that time." The nephew said, "Okay." And they had a deal. And for the next 3 years, the nephew did not smoke, drink, cuss, or play billiards. And he went to collect. The problem was his uncle had died, and the executor of uncle's estate, when he got this claim, said, "Kid, you've got to be kidding me. There's no way I'm paying you $5,000. Imagine how much $5,000 would be worth in 1891. It's a lot of money. And so the executor refused to pay. Hamer, the boy, sued Sidway, the executor, and the court said, this is a promissory estoppel. The uncle made a promise. It is true he stood to gain nothing from this, but because he made a promise and because nephew relied on that promise in good faith and actually changed his legal position, he gave up some legal rights. He is entitled to payment. The other term, by the way, for promissory estoppel is detrimental reliance. The nephew very much detrimentally relied on the promise. He gave up all those fun things for 3 years. But there are many examples of promissory estoppel in reality. That's just the fun one, easier to remember. The third element of an enforceable contract is capacity. I say mental state. This issue doesn't come up very often in contract law. The only time I've ever really seen it come up is if somebody had dementia, had a mental incapacity issue, and they entered into a contract. Occasionally the court will say, look, they didn't really know what they were doing, so we're going to excuse them from the contract. The bigger issue that comes up is age. I want you to know the rules in Kansas. In Kansas, someone who is under 18 and enters into a contract can get out of that contract. In other words, it is not enforceable. But there are a couple of catches. First of all, if a 17-year-old signs a contract, let's say, she can get out of that contract, but she has to notify the other party of the contract of her intent to do so shortly after turning 18. That's a technical point. But the courts also will recognize contracts made by people under 18 if they're married and at least 16, and if the person is living on her own and pretending to be adult, and what's called emancipated. They've left home and actually are living as if they were an adult. So the main point of this is there are some exceptions to the age requirement. This one's very straightforward. The subject matter of the contract must be legal. And that just means that you can't make a contract that's enforceable in court to sell cocaine. Certain gambling contracts are unenforceable. This one usually is not problematic. It's most of the time we pretty much know when there's a problem. I said earlier, posed the question, what is a contract? Now we want to talk about what is the contract. Technically, the contract is the meeting of the minds of the key terms of the parties. Now, for most of us, when we sign a contract, this isn't very difficult. For businesses, it can be. You know, as a lawyer, I used to work on some contracts for clients that were very involved and took days, weeks, maybe even longer. So here's the scenario. Two business people, presidents of companies. One calls the other and proposes a deal. Big picture. They're just talking. The other person listens and says, yeah, that sounds intriguing. They go back and forth for a little while on the phone, and eventually they have the equivalent of a handshake agreement, a general agreement on all the key terms. Then they turn it over to the lawyers for the respective companies who spend weeks tweaking it and adding massive, massive details. Which is the contract? Here's a way to think about it. Technically, it's the meeting of the minds between the executives, the handshake agreement. But in reality, it's going to be the final written contract, probably for obvious reasons, because we do need to nail down some of those details. And that leads to the question of when there is a final written contract later, and the parties have a breach of contract case and they're in court, how does the court go about trying to figure out what the terms of the contract really are? Because you see, in a breach of contract case, the parties are arguing about what they intended. And very often, even if there's a written contract, they'll be saying, yeah, I know what it says, but here's what I understood it to mean. And of course, they have a difference. There are certain rules of interpretation that judges apply in these cases. The first is, and this is really important, the Four Corners Rule. And the Four Corners Rule is a rule of law, of Kansas law, that is always applied when the parties are in court arguing about the meaning of the written contract. And the term comes from the idea of the four corners of the document. And what it means is this. When parties get to court and are arguing about the meaning of the document, the judge says, basically, I have to read it, and I have to decide if I can understand what you intended when you made the contract. Today, you have different interpretation, and in other words, they don't really trust them. What they're saying is the best evidence of what the parties intended is to read the document they signed, because back then they were in agreement and they were all looking at the same document. So that's how it works. The judge reads the contract. If the judge believes, and this is the important part, that whatever the dispute is about, the issue that they're disagreeing on, if the judge believes that the written contract is clear and unambiguous on that point from the document, the judge will interpret the document as written and understood by the judge, and the parties are not allowed to provide any oral evidence of what they intended. Case is over. If, however, the judge reads the contract and says, I have no idea what you guys intended when you signed this thing. I'm confused. Therefore, I have no choice but to put you both on the witness stand and hear your testimony about what you understood, and then I'll decide. And that's how the Four Corners Rule works. A second issue that comes up for very often that makes the final contract the critical document. And by the way, it's called various things. I call it the integration clause. Often the contract itself has the label entire agreement clause. But this language is almost standard in business contracts. The parties agree that this contract, meaning the written contract, contains the final agreement of the parties in all respects. Now, what that's saying is, yeah, okay, technically the big picture contract between the executives is what matters, but we're saying now jointly that everything that we want is in this piece of paper. And the second line, the parties acknowledge that they have not relied upon any other statement or agreement, written or oral. What that does is that cuts you off from any argument later that, Judge, I know what the document says, but there were some other discussions that we had that didn't get in the contract. The judge said, that's too bad. So sad. Look at this. You're saying there wasn't anything else. I have this, I used to go in a lot of detail in the restaurant lease. I'm just going to give you the short version. This is a real case that my law firm handled years ago in Wichita. One of my law partners was the attorney for the landlord. And I'm going to spare a lot of the details about the actual facility. But the simple version is that it was a restaurant lease. And the landlord leased some land to a man, I'll call him Jim. Jim had a dream of building a franchise restaurant. Gee, that's novel. And it was bare land. And the landlord signed a lease saying, yeah, I'll lease this land to you 5 years. You can build your building at your cost, and then you pay me rent. And that's what they did. 5-year lease. After about 2 years, the restaurant closed. That's novel. And it turned out Jim was in way over his head on many levels. He didn't even have a lawyer help him with any of this lease stuff. And when he closed the restaurant, he still had 3 years rent. Landlord sued him for 3 years future rent. Jim's argument was, I'm not liable for future rent because the reason my business closed, landlord, is because you broke your promise to me. When we were negotiating this lease, you told me you were going to give me X number of parking places at your cost. You were going to pave it and give me these parking places. You were going to give me more access points. You were going to give me this huge honking sign. You didn't do any of those things. And the landlord's response was, did you read the contract, Jim, that you signed without a lawyer? Did you notice that it had an integration clause that said this contains the final agreement of the parties and there are no other promises that are important that aren't in here? And oh, by the way, the Four Corners Rule. And they went to court. And the judge said, on the Four Corners Rule, applying Kansas law, said, I don't see anything in this contract about parking, light, signage, or anything else that you're talking about. The judge said, therefore, it is clear and unambiguous. It isn't in here. Secondly, integration clause. And he ruled against the tenant, and that was that. So he actually lost on both counts. Now, for this course, I have to stick in marriage somewhere. And in my business law for accounting classes, I have a family law lecture, so it goes there. But I do want to talk about this for several reasons. I'm going to go through this quickly. What is marriage legally? Legally. Because obviously marriage in an informal sense has been around for a long time. I've recently been doing a research project in Virginia on some former slaves. It's kind of an interesting project. And until the end of the Civil War in Virginia, slaves could not marry legally. I mean, the U.S. Supreme Court said they weren't even people in the Dred Scott case. So it's horrible. But they did marry. And the way they married was informal, wasn't recognized by the law of Virginia, was they literally jumped over the broom. There was a ceremony. Well, ceremonial marriage has been around for thousands of years. Marriage in the modern sense, in the legal sense, only been around a short time. So what I'm going to talk about right now are the two categories of marriage legally. The first is civil marriage or statutory marriage. This is a good example of the legislature tweaking the common law. And in Kansas, a number of you were probably married. You go down and you apply to marry the county. You get a license. You have to marry within 6 months, or the license expires. You have to have somebody who's authorized to perform the marriage, although today you can get somebody get authorized on the internet in about 5 minutes. But the point is, there are some requirements that we have. There's a 3-day waiting requirement in Kansas between the application of the marriage and the marriage ceremony. Why? Buyer's remorse, literally. 3 days to change your mind. Then there's common law marriage. Common law marriage, there is no ceremony. There is no statute that sets out what it's supposed to be. So it literally comes from the common law, the way people used to get married before there was statutory marriage. By the way, I do a lot of genealogy too, and marriages were not recorded in most states until, well, certainly in most states until the last 150 years or so. Some states were a little better about it. It's a fairly modern concept. So let's talk about two things. First, what is the minimum age requirement in Kansas for marriage? Well, there was a very embarrassing case in Kansas a number of years ago that got national attention. What happened was a 19-year-old guy in Nebraska wanted to marry his 13-year-old girlfriend. Nebraska had a minimum age requirement, so they came down to Kansas to get married legally, and her mother signed off on it. They got married in Kansas legally. Went back home to Nebraska, and he was arrested for statutory rape and went to jail. And the Kansas legislature, when this hit CNN and everything, goes, wait a minute, what do you mean we don't have a minimum age in our statutes? Nobody told me this. And I mean, that's exactly what happened. Nobody seemed to realize we had no minimum age in Kansas, the only state in the United States that did not. By the way, this is only in the last 10 years or so. So the legislature, in its infinite wisdom, passed a minimum age, and here's what it is. To get married under civil marriage in Kansas now, you must be 18 if you don't have your parents sign off. If your parents sign off, you have to be 16, at least 16. So that's how it works now. Common law marriage, let's talk about that. To prove common law marriage, you have to have two elements. And I say prove it, well, if there's no ceremony and no piece of paper, how do you prove it? It only comes up in two situations. When someone dies and the other person who's been in a common law marriage wants property, because you see the marriage statutes are set out property distribution to people who are married under the civil law. So sometimes people will go into court and say, wait a minute, I'm actually a common law spouse, I'm entitled to this property, and they have to file a lawsuit to prove that they're married under the common law. The other situation is divorce. When the couple breaks up, and when in divorce law, there's all kinds of rules about distribution of property. So I had a common law marriage case once. A man died, and his wife, under common law marriage, was denied his military benefits because the military doesn't recognize common law marriage. And so I had to file a lawsuit in Kansas court to have the court declare that the couple was married under the common law of Kansas. Kansas does recognize common law marriage. And I did, and we won, and therefore she got her benefits because there was a piece of paper from a judge saying they were married. I should point out the military was very nice to her all along and said, just go get a piece of paper from the judge that says it's okay. So she got her benefits. But I learned from that, wow, common law marriage is actually quite difficult to prove. Here's how you prove it. Two elements. Remember these two elements. One, you have to show that you had the present intent as a couple to marry, that both of you intended to be married, not in the future, that's called an engagement, but you were married in the present tense. So intent is the first element. Second element, I call it holding out. It's a phrase meaning that the couple, during their time together, held themselves out to the public, friends, coworkers, whatever, as being married. They refer to themselves as husband and wife. They sign paperwork husband, wife, and so on. There is no minimum age requirement. Excuse me, let me back up. You have to be 18. There is no minimum time together. There's an urban myth that common law marriage can be created if you live together a month, a day, 6 years, whatever. That may be true in some states, but in Kansas, there is no minimum time of living together. It's based on the two elements that I described. I've updated this. It's actually changed a little bit. Some states have done away with common law marriage recently. There's two issues to understand here. These states and the District of Columbia still allow people to contract within their states as residents to be married under the common law. This list has dwindled over the years, as you can imagine. But some states do, actually all states, I think, still will occasionally recognize a common law marriage of another state, like Kansas, if the couple moves to a state. And this is where it gets complicated. Here's my advice to you, given what I've seen. If you want to be married, no matter how you may feel about the man or, formal marriage, if you want any rights as a spouse to inheritance through divorce, otherwise, you better go get married under the civil law piece of paper, a license, certificate, now and in the future. You don't know where you're going to be living years from now. It will save a lot of headaches. Then there is the issue of same-sex marriage. I just want to run through this very quickly. As you can imagine, Kansas statute and the Kansas Constitution have for some time made it very clear that same-sex marriage is illegal in Kansas. Kansas wouldn't allow a same-sex couple to be married and would not even recognize a same-sex marriage made in a state where it was legal. So if a couple were married in Vermont, for example, where it's been legal for a while, if that couple then moved to Kansas, Kansas would not recognize the marriage, and therefore the couple would not have spousal benefit rights under the law. Well, that was done away with by the U.S. Supreme Court case, which I think I've already mentioned, which I'm going to get to in just a moment. But this is what Kansas had to say about it before that Supreme Court case. So the full faith and credit idea was that states generally recognize laws of other states, but in the case of Kansas in marriage, we didn't. DOMA was actually a federal law that did not recognize, for federal purposes, same-sex marriages. And all of that has been done away with by the U.S. Supreme Court. The U.S. Supreme Court has held now in two different cases. First of all, it shot down DOMA as unconstitutional, and then in the Obergefell case in 2015, the U.S. Supreme Court held under the equal protection and due process clauses of the United States Constitution that all states have to allow same-sex couples to be married within those states, and that all states must recognize same-sex marriages made in other states. Now, it's very controversial still, but that is the law of the land. So that concludes Contracts Part 1.